We are live.
Good evening and welcome to this meeting of the Cannabis Legalization Work Group. This is a virtual work group meeting, so bear with us if we have any technical or streaming issues. Before we begin, I'll remind everybody that this briefing is being streamed on the General Assembly's YouTube channel. Work group members will be muted through the briefing. If you have a question after our presentations, use the raise your hand function within your Zoom window. I want to thank everybody for being here. It's a very busy time for everyone, so we'll get underway with our work. Tonight, we're going to hear from Matthew Swinburne of the University of Maryland's Francis King Carey School of Law. He will provide the work group with a presentation of the Social Equity Toolkit, a recently updated and detailed survey of what other states are doing across the nation with regard to issues related to social equity, and licensure related to cannabis legalization. After his update and presentation, I'll open the floor to questions and answers between our work group members and Mr. Swinburne. And so with that, and to get this on the road, I'll welcome Matthew Swinburne here, and we will hear from you. Mr.
Great.
Swinburne.
Thank you for having me here tonight to speak with you folks. I'm waiting for my PowerPoint to be shared. I was told that, oh, awesome. Thank you, Will. Thank you.
There we go.
So I am with the University of Maryland School of Law, but I'm also part of the Network for Public Health Law, which is a legal nonprofit that provides support to folks who work in the public health field. And tonight, I'm going to introduce you to some research that my colleague Brianne Schell and I did regarding the social equity policies of adult use states and the different policy approaches that we're seeing. But before I jump into that and jump into our research, I'm just going to do a little foundational discussion of why states are this is a critical issue for states as they contemplate legalization. Next slide, please. So we know that the cannabis industry is a profitable industry, and this is an industry that will continue to grow in value. This is some information from New Frontier data that projects that sales could be approximately $72 billion in the licensed market by 2030. So this is a new industry that is filled with economic opportunity, and that opportunity is only growing. Next slide, please. What we know is that although this industry presents some significant economic opportunities, communities of color are missing out on this cannabis boom. And we have some research from a few years ago that indicates that 81% of cannabis businesses are owned by white individuals, with only 4.3% of owners identifying as African American. Now, these numbers may be lower because I've seen another study that looks at Black ownership of cannabis businesses that has it closer to 2%. And when we look at this percentage, it's important to point out that an ownership interest doesn't denote a controlling ownership interest. So if we were concerned with a controlling ownership interest, it's likely lower than the percentages we're seeing in these reports. Now, we've got to look at that percentage of ownership in comparison to representation in the general population. So if African Americans represent approximately 13% of the US population, we see that disparity between the population and business ownership interests within this industry. And this is really juxtaposed when we look at this, and we need to look at this through a racial justice lens. When we look at how drug laws and cannabis laws specifically have been enforced and how they continue to be enforced. Now, even with legalization happening in states across our country, The ACLU put out a wonderful report called The Tale of Two Countries that shows that even with legalization, Black Americans are still more than 3.6 times more likely to be arrested for cannabis possession than their white counterparts. So, we still have this issue. But the one thing that I want to point out is that this lack of representation in the cannabis industry isn't a cannabis specific issue. This lines up with, business ownership in general in the United States. And this data I have at the bottom is data from the Census Bureau that shows that only 18.3% of businesses are minority owned. And you compare that to this data we have on the cannabis industry, and you see the correlation. But I think the important difference here is that this is a new industry. This is an industry that is being built now by states. And so there's an opportunity to try to put mechanisms in place to address representation, equity, and inclusion in the economic opportunities that this represents. Next slide, please. So what I'm going to talk about in a little bit is really going to focus in a large part on ownership. And why is ownership of these businesses important when we're talking about the economic opportunities? There's the obvious reason of the value of these businesses and the value of the licenses themselves. But as I said, this is a growing industry that's creating a lot of jobs. And we see impressive job growth in this industry. And we know that our country has a problem with racial biases in hiring practices, so that if you have minority representation in ownership, you're going to increase the economic opportunities, throughout this industry. And I've just pulled some data from a couple studies here to kind of emphasize that ownership matters in the additional economic opportunities, the additional jobs within this industry. Next slide, please. So one of the things that I want to highlight is a critical barrier that we're seeing to equitable participation in the cannabis industry. And we've got to break it down into a group of related factors. So it costs money to be part of this industry, and it's an expensive industry in terms of application fees, licensing fees, startup costs, continuing, kind of operational funds. And we know in this country, there are racial contours to poverty. And so this creates the initial obstacle to participation in this industry. But the other obstacle we have is that because cannabis is still illegal under federal law, the vast majority of banks won't provide services, specifically loans, to cannabis businesses. And there are some financial institutions that will, states within this, but the vast majority do not. And without the kind of traditional access to capital, you see a lot of the businesses that are entering this space relying on their founders' savings. And so looking at all these factors together, there is the financial component that is a big barrier to entry into this industry. And that plays into some of the variables we will look at in terms of state approaches. Next slide, please. So the resource I want to introduce you to so that you have access to this, your staff has access to this, is the social equity toolkit that we created. And there are a couple things that I want to highlight about this resource so you understand the type of stuff we'll be going over today. So, in this research, we looked at the 20 jurisdictions that currently have adult use cannabis, and this fall that the number of states may change with all the ballot measures that are out there. But in the sample set, there were key things that kind of affected our sample set. DC lacks a licensed market, even though adult use is legal in the district. And there are 4 states that do not have social equity programs, but do have a few, these states that I've highlighted have a couple policies, for example, micro business licenses that could be used as a tool for equity and inclusion in the cannabis space, but they lack, a social equity program. Now, the 2 areas that we focused our research on was first, the foundational question of who qualifies for a state's social equity program. Who's going to have access to the services that the state is providing to try to increase diversity. And so we identified 10 variables that states are using in defining that social equity applicant or licensee. And then following that, we looked at 10 policy variables that states use to focus on increasing equity inclusion as well as community reinvestment. Now, this slide actually links, the red title links to the document on my organization's website. And what this resource has, it has a summary of all the policy variables that we're going to look at tonight in terms of their prevalence and the variation within those variables. We have charts that allow side-by-side comparison of jurisdictions so that you can, see how they match up on these different variables. And then we have state-specific summaries that address all the policy variables that we're going to look. So if you're really interested in, let's say, what New York was doing, you could go directly to the New York section and read up on how they approach these issues. Next slide, please. So the foundational question, who qualifies as a social equity applicant or licensee? So here are the 10 variables that we did our research on, and the most prevalent. So with this, the sample set was 15 states because of the 4 states without equity programs and DC's lack of a licensed market. Every state except Connecticut used cannabis offenses as a qualifying metric. So if an individual had a cannabis offense or often was related to an individual with a cannabis offense, so specific family members, that could be used as a qualifying metric for the social equity program. The other big tool that was used in terms of defining this population was the concept of disparately impacted communities. So communities that were harmed by the war on drugs. And there were common kind of metrics in determining which communities qualified for this. And, they looked at arrest rates related to cannabis, poverty rate, government benefits. So whether it was participation rates in the school meal programs or the SNAP programs. And so individuals who were from these disparately impacted communities could qualify for the social equity program. Income was another qualifying metric that is used in 10 states. And next variable, race. Race was another qualifying metric. And so, to kind of give you an idea how some states structure these, that, I'll use New Mexico. New Mexico has a list of qualifying metrics. And if you meet 2 of those qualifying metrics, you are then eligible as a social equity applicant. And they have an income requirement. So, if your income is below the state median average, that's a qualifying metric. And if you are a member of a designated minority in that, those 2 metrics would qualify you. Or you could be a farmer and a member of a designated minority group in the state for this program and qualify. So these variables often interact with each other. The next variable that we found was employee characteristics. So did the license or the applicant employ individuals from a disparately impacted community, or did they employ individuals with cannabis offenses? That could qualify. And, I think this metric can create some friction, because if you're looking at the issue, what is the state's goal? If you're looking at racial inclusivity, this is a metric that subverts that often. And that's the criticism of this in some jurisdictions, is that, something like this would allow an old white guy who looks like me to secure a social equity applicant status. And so some of these characteristics, as states are developing their policy, are creating some friction. Gender is another issue that some states use as a metric. Disabled veteran status, I know New York and New Jersey use that. Being a farmer in New York and I think New Jersey again, and it's often distressed farmers. So, individuals who've come across economic challenges in this profession. Gender identity is a qualifying metric in New Mexico, but I know there was legislation in New York to include gender identity as part of their social equity program. And New Jersey is the only state that allows kind of the location of your proposed business to be a qualifying metric. So if you were looking to open your cannabis business in a disparately impacted area, that could qualify you. So these are kind of some of the baseline issues that states are kind of using to define the population they want to help with their services. Now, on the next slide, I'm going to talk about a medical state, because last time I spoke with this group back last year, the issue of licensing systems around Black farmers, and specifically Florida's Pigford Black farmer litigation license system was brought up. And I did some research for Delegate Wilson last year. And so I wanted to cover this because I know it's an interesting approach, but it kind of fell outside the realm of our toolkit because Florida is just a medical state. So next slide, please. So we're going to talk about this because this is a very explicit use of race in a cannabis licensing system. And so I'm going to give you a little history about Florida's medical program and kind of the story of this licensing approach. So Florida started out in 2014 with a low THC medical cannabis system. So, I believe the term they used was non-euphoric cannabis. And they had very high qualifying standards in terms of the longevity of the businesses that were applying and essentially the size of the businesses in terms of their output. And so in this system, their low THC medical cannabis system, it was not a diverse applicant pool because of this kind of high barrier to entry. But in 2016, the state legalized what we think of as medical cannabis. So the full spectrum, allowing THC in those products. And what Florida did is they essentially rolled over the businesses that were in that low THC medical system and gave them licenses, which they refer to as medical marijuana treatment centers. And these are vertically integrated licenses. And currently they have 22, now 23 licensed medical marijuana treatment centers. And rolling over their old system that lacked diversity led to no diversity in their new system. And so in 2017, they increased the license cap for their medical system, and they created one license, which was specifically targeting Black farmers. But they narrowed that population of farmers to individuals who had been a part of either the Pigford v. Glickman or the In re Black farmers litigation. And these cases revolved around racial discrimination by the USDA against Black farmers in the provision of farm loans and in other benefits during the 80s and 90s. And I think the class qualification was like 1981 to the end of 96. And these were individuals who had been discriminated against and attempted to file complaints about this discrimination. But the problem was during this time period, the USDA had functionally shut down the Office of Civil Rights, that was the arm that was supposed to be responding to these complaints. Now, this litigation was settled, and it was a huge, settlement in the billions. But this is the population that Florida wanted to target. And in 2017, they created this one license that was going to be designated for Black farmers who were part of this litigation. They just awarded this license in 2022 to Mr. Terry Gwynn. And it's the first Black-owned license in their medical cannabis system. It is the second minority license. Latino individual purchased a license to become the first minority owner of a license. So there is a lack of diversity in Florida's program. But the reason it took so long for them to get this license out was there has been a lot of litigation surrounding their licensing system. Some of the litigation specific to this, Pigford license, and some of it to kind of the constitutionality of the licensing system itself. But this is really kind of a unique, interesting approach to incorporating race into the licensing system. So that's why I wanted to highlight it. Next slide, please. So these are the 10 policy variables that states use in their social equity programs. And I'll briefly go over each of these variables. And the ones I have highlighted in red, I'm going to go into a little more detail in a few slides, because I know there's been some interest expressed to me in regards to incubator programs, kind of leveraging the technical know-how and resources of the existing licensees to help support the state's equity program. So we'll go into that. And then there's some special licensing opportunities that have developed recently that I think folks would be interested in. But the first thing we looked at was kind of the issue of community accountability for your equity program, and that being, states setting a concrete DEI goal. So saying, not just saying we're focusing on equity in this industry, but saying we're allocating a specific number of licenses to social equity applicants. And that's what Arizona does, is I believe they've set aside 26 licenses specifically for social equity applicants. New York does a different approach, where they've said they're going to award 50% of all adult use licenses to social equity applicants in their program. And kind of a related tool that some states use is they establish an equity lead. So they have a position within their regulatory agency that is responsible for overseeing the equity program, or they create an equity council, an advisory group that oversees and is involved in this. And so we found 12 states that either use that individual lead or kind of that equity council, kind of group of individuals focused on that. Now, in terms of license, we see some interesting licensing practices. 4 states identify as having what they refer to as license priority, meaning that social equity applications will be reviewed first. And Massachusetts is a good example of this, so that when a social equity application is submitted, it goes to the front of the line, and those non-equity applications have to wait until that social equity application is reviewed. Now, in very confusing, similar terminology, licensing preference. Several states say they have a licensing preference, and that indicates that there's a scoring preference if you are an equity applicant. And we're going to talk about Illinois because it's the only state that actually has defined what that preference is at this point. So in Illinois, they score cannabis licenses on a 250-point scale. If you qualify as a social equity applicant, you automatically get 50 points on your license. So it facilitates getting a better score. And in a capped market, those higher scores are very important to earn the license. Now, talked about financial barriers. Most states in this provide some sort of financial services to social equity applicants. And there's a range of services that they make available, as simple as reducing or waiving application or licensing fees to lower that initial cost, to providing low to no interest loans or grants to help, applicants as well as licensees establish themselves in the market. Training services, and this is, helping social equity applicants get the technical know-how they need to succeed in this industry. Some situations, it's the state providing the services or the state hiring contractors to provide these training services. But in 4 jurisdictions, they have kind of the incubator accelerator model, where they leverage the financial resources and the experience of existing licensees. Micro business license, I mentioned this earlier. This isn't specifically targeted at equity applicants, but because micro licenses have lower startup costs and generally lower application and licensing fees, they can be a tool to help increase representation within the industry. And the wholesale license is another category of license that doesn't directly target, but has reduced kind of initial input and a lower buy-in cost. So those are 2 similar policies. And the second to last thing that we looked at was special licensing opportunities for equity applicants. So, a licensing opportunity that is exclusive to an equity applicant. And you see the use of things like exclusivity periods. So it may not be exclusive indefinitely for equity applicants and licensees, but maybe for an initial period of time. And we'll look at 2 examples of that. And then community reinvestment. There is going to be a lot of tax revenue coming in from adult use markets. And we looked at what states were reinvesting funds from their adult use market to the benefit of those disproportionately impacted communities. So making funds available for things like community development, business development in these communities, job training, youth programs, reentry services, a broad spectrum of funding for services like this to help address some of the damage that was done by the war on drugs. And this is something that Maryland has already, addressed, looking at HB 37 and the Community Reinvestment and Repair Fund. Next slide, please. So this is, I think, an interesting example of the incubator kind of accelerator model, is what Connecticut has put in place. And this is similar in part, is similar to the Illinois model, but this, I think, is easier to follow in terms of some of the structure of it. So we know that there are going to be medical licensees who want to participate in the adult use market and become hybrid licensees. Well, there's usually a fee associated in that dual licensing. And so in Connecticut, they have a conversion fee. And so for producers in their medical market who want to be hybrid licensees or dual licensed, there's a $3 million conversion fee and a $500,000 payment into an equity fund overseen by their social equity council. Now, dispensaries in their medical market have a $1 million conversion fee. Now, these businesses can cut that conversion fee in half if they participate in the equity joint venture program. And basically, that has these licensees who want to be dual licensed going into business with a social equity applicant. So if they go into business with a social equity applicant for at least 7 years and do not have a controlling interest, so they're limited to a non-controlling interest, they can get that reduction in that conversion fee. And to qualify for this reduction, the producers have to have 2 of these relationships, whereas the dispensaries only have to have 1. Now, with regards to that $500,000 payment to the Social Equity Council Fund, producers have this option of the equity partnership. Rather than making that payment, they can provide 5% of their gross space, along with mentorship, covering overhead costs, helping with regulatory compliance, in lieu of that payment. But all the profit from that gross space that they're providing to the social equity applicant has to go to the social equity applicant. And they have to have this arrangement for at least 5 years to qualify for the waiver of that $500,000 payment. So it's an interesting way that they're trying to use a financial carrot to leverage the experience and resources of existing licensees. Next slide, please. So to just kind of highlight some of the special licensing opportunities that have been created for equity applicants. We look at Massachusetts. They have a very straightforward model. They created 2 delivery-based licenses. So a license category with a much lower buy-in cost than, let's say, a cultivator or a processor. And they've made these licenses exclusively available to their state's social equity applicants for a 36-month period, but they've reserved the right to extend that exclusivity period to help further achieve their DEI goals. So you've got this example of an exclusivity period to a more accessible license being made to social equity applicants. Next slide, please. So you've probably heard a bit of chatter about New York and their conditional adult use retail dispensary licenses. Yes, there's a reason there's an acronym for that. That's a mouthful. But this is their first round of adult use retail licenses. And these are being made available exclusively to 2 categories of social equity applicants. And I'll explain the 2 populations that this targets. And then we'll look at a really, I think, interesting and unique investment that the state is making in these folks. So they're looking at awarding around 175 licenses through this. 150 of those licenses have been designated for businesses with justice-involved individuals. And so this is a term for individuals who've been convicted of a cannabis-related offense in New York prior to legalization, or they have a family, a specific family member with that type of conviction. Now, these businesses, the justice-involved individual has to have sole control of operations. They have to have a significant connection to the state and certain business experience, but it's targeting a category, kind of a subcategory of their social equity population. Next slide, please. So the next group that's targeted in this first round of retail licenses are certain nonprofits. And these are nonprofits that provide services to justice-involved individuals and communities that, essentially have been disproportionately impacted by the war on drugs. Now, these nonprofits have to have a justice-involved individual on the board or as an executive officer, and they have to have a history of creating vocational opportunities for these folks. But if you qualify for this license, you have this conditional license awarded. This is where I think the really interesting aspect comes in. So New York has created this special fund, and I left out a word here, but it's the Social Equity Investment Cannabis Fund. So this is an investment fund that's receiving $50 million from state licensing fees and is raising the other $150 million from the private sector. And this investment fund will be managed to allow the state to acquire properties for these retailers. So the state will acquire retail locations, build them out so that they are compliant with the state's requirements, and then they'll sublease these to licensees. Now, this is interesting, this I think is an important resource, because when you look at a lot of, the information that's out there in terms of the challenges for social equity applicants, identifying a location, and it can be a huge challenge, especially with zoning restrictions that some states have in place or some local jurisdictions have in place. And there is, an upfront investment that is required in establishing that retail location. So the state is investing these funds to try to remove that barrier to participation. So it's an interesting and unique approach to a special licensing opportunity. Next slide, please. And I promise this is I think my last. So just kind of continuing challenges that, I'm hearing about in the field, and just, want to drive home, until the federal government resolves the banking issue, lack of access to capital will continue to be a challenge. So it really, I think, drives home creative thinking on behalf of the states on how they can support removal of that barrier. I think the next two issues kind of go together. That states need to have a clear goal. What do they want to achieve in terms of their equity and inclusivity goal? What do they want this program to create? And because that definition of a social equity applicant is so foundational, are some definitions too inclusive or under-inclusive? And states, I think, are struggling with that. And, the example I gave was kind of, allowing social equity status if you employed individuals from a disproportionately impacted area. I think another thing that, folks are familiar with is the dual licensing conundrum, that if a state doesn't have a diverse medical cannabis industry, that's the industry that states rely on to kind of stand up their adult use industry quickly. And so that lack of diversity flows through into the adult use industry. So it's a challenge. And then I think it's just the need for continual evaluation of state programs in terms of what are the barriers in your system to that inclusivity. And so, one of the issues that comes up is the complexity of the application process is something that I hear a lot about. And just to kind of give an example of that, when we talked about the Pigford license in Florida, the instructions for the application were 70 pages long. So it's an issue that states need to be aware of in their process. So that's an introduction to the research we did in terms of state policies, and I'm happy to answer any questions. Next slide. Or try to answer any questions.
Okay. We're going to have several questions right out of the gate here. We'll start first with the chair of the Economic Matters Committee, Chair Wilson. And we're going to go to Senator Melanie Griffith right after that. So although I just lost CT Wilson.
I'm here.
Oh, there you are. Great. Okay. Delegate Wilson first.
Thank you, Chair. So I just have a few questions. First of all, I just see some vacillation here with statistics, because sometimes we use the words Black and then sometimes we use the word minority. And I would caution anyone listening as well that not conflate the two, because that's something, obviously, I hope that our disparity study opens up somewhat when we're talking about minorities, because by that standard, we're talking about everything from Asians, East Indians, West Indians, African Americans, Africans, white women, black women. We're it's a huge bite. And so I guess I'm wondering, because some of the statistics you brought up, we're talking about blacks, African Americans, 4.3, and I believe it's around 2, honestly. When you talk,
well, that's what I mentioned with the Leafly study.
Yes,
said that it was closer to 2.
right. And of course, and I'm not, I remember you did mention that, but it was just that whole, and then we talk about, the 18.3 businesses are minority owned. And those are 2 entirely different sets of people. And I don't know, for us, I don't know how we can juxtapose the 2, because go ahead.
Well, I think the reason that, we use those statistics is because states, in defining their goals, many states try to address issues to the more expansive minority definition, including Latinos, Native Americans, Asians. So you do see some states being in their use of race more expansive, and you see some being more restrictive. So,
minority just isn't race though, and that's kind of what I was talking about.
Okay.
So, and I guess that's up to us because I know what my focus has been more on communities that were disproportionately impacted by the war on drugs, not necessarily anybody who happens to be a minority. I want to go into the Pickford v. Glickman lawsuit. And I worked on that in law school. And I've been bringing that up for years here. One of the things that I thought that was very good, because it really focused on horticulture, i.e. agriculture, and African Americans. Obviously, Florida bastardized it as much as humanly possible to narrowly tailor it to just, allow basically one family to participate. But the idea that I understood from the readings of Pickford or Black Farmers 1 and 2 was that just generationally African Americans have been disenfranchised from the growing and farming communities. I've actually visited one of the growers. He's a 4th generation grower. He had the benefit of his grandfather owning, that grew flowers and trees, which again, as African Americans, I think it is a broader hit than just say that you had to be related, especially when individuals from the African American communities don't often know their relatives. So, and I think that's something that needs to be taken into account. Myself, I don't know any. There are a lot of people who can't trace their lineage back more than a generation, so they can't really testify that they are truly and definitively impacted by that USDA oversight for 100 years. So again, I think that is something worth going down to. Now, granted, I think it only applies to growers if we're trying to avoid the issues that Croson brought up, but I do believe that can still be of value to Marylanders. We had talked about, and I guess you brought it, the community investment, the 10 policies of the variables. Could you please tell me about the community reinvestment from the taxes? Could you kind of juxtapose that with the increase of black market? Is there something to be said for the more you tax it, i.e. to get
I think that's a challenge. That's a definite challenge that states are confronted with, is that, if part of your goal is to decrease the share of the unlicensed market, you have to keep your licensed market competitive from a financial standpoint, so that when people are making their decisions, that the licensed market is the easy decision. But states will often see large numbers coming out of states like Colorado and going, oh my gosh, we can fix everything in the state. No, you will not be able to fix everything in the state. And so that's why I think it's important to highlight, with the tax revenue you get, there's almost, there's a moral obligation to use some of that for, addressing the harms that were caused. But there is that tension that, the more we tax, the more money we'll get, the more good we can do. But that's going to impact your ability to compete with the unlicensed market. And it's a real challenge, and finding that right mix. And there are many different,
that's what
I'm sure you all know, approaches to this.
Because I know when people hear that, they get very excited, like you said, and it was just it's a cautionary tale, because I don't believe our job is to get Marylanders high as much as it is to take this out of the criminal stream of commerce, stop people from getting arrested for marijuana or murdered for marijuana. So but I appreciate you bringing up that tension, because that is something we have to decide. Last, I want to talk about the joint ventures, because I guess what I didn't understand is it sounds like individuals, and depending on the state you lived in, Maryland, is what we're working with, who may have gotten to the front of the line, i.e. they already have their medical grower's license. And we've had a very difficult time with our medical marijuana, especially the initial rollout, getting African-American or minority participation, period. But it sounds like what they're doing is allowing them to make more money, because they will invest up to 50% in a budding business or two. And therefore, I don't see this as any remote, it's not a sacrifice at all. It sounds like just another way for them to franchise out and make more
I don't
money.
think it's meant to be a sacrifice. It's trying to access, the resources that they have to help with that initial establishment of the social equity business. So yeah, it is an attractive carrot. That's not, and it's the way that, and the accelerator programs are, I think, a kind of novel approach that states have taken. New York is one of the 4 states. They said that they're going to create, but they're kind of in the nascent stages. They've developed some, I saw an announcement recently for kind of webinars for prospective licensees that incorporate, those existing licensees. You have a similar program to Connecticut in Illinois,
Right.
where though, a waiver of some of those fees if they either do, and I'm trying to think of there's a partnership where they provide guidance and essentially are a funding source, a no interest loan to a social equity applicant, or they can do a sponsorship where they just essentially make a $200,000 no interest loan to a social equity applicant to try to help them get established in the industry. And so it's getting to that issue of the lack of the traditional financial resources, and rather than having the state be the provider of that kind of financial support, leverage the industry. And then Colorado is another one that folks focus on in this area, the accelerator and accelerator endorsed licensee system. And that is, I think, a less structured system than what Connecticut has, but it's this idea that it's partnering the existing licensee with a social equity applicant for the mentorship and training on important business aspects, and helping with the acquisition of capital, and in providing kind of that I don't even know what the appropriate term is. It's beyond a mentorship.
Yeah, but I don't understand. I guess I'm caught a little nervous about making the rich richer in our movements forward, because again, if they can own up to 50% of another new business that we, as you've seen by your graph, is going to make money, it's not really a sacrifice. It literally is problematic. It's one thing, like you said, to give these interest-free loans and some mentorship. It's another thing to say, well, we're going to own this as well, or we're going to own part of this as well. And lastly, and I'm sorry because you did bring it up, it bring my memory when we were talking about New York, and I've heard a lot of people talk to me about targeting individuals that were convicted for drug offenses. But to be clear, that is not necessarily targeting a community of impact, is it? Because because that could be.
Yeah, no, and that's an issue.
A white male whose son or grandfather or father was convicted of selling or possessing weed could also be now considered for these equity
justice involved individual. Yeah. So it doesn't get to the issue of kind of the racial equity, because it is more expansive than that.
Right.
But we know how drug laws have been enforced, I think, is the idea behind it, that there's the potential. But you're going to have, white folks.
We also know how loopholes have been made through these systems to exclude the minorities that are trying to save. So I just wanted to make that clear. And again, I really appreciate your research, and I've written down a lot of notes. I'm sure we'll be talking again.
Well,
but it's always
tons of information in the toolkit itself. I've shared it with a couple folks. It's got a lot of information. It's fairly easy to use. So I just encourage folks to check it out if you've got really specific questions that my old man memory can't address.
Well, thank you very much, sir. I appreciate your input.
Thank you. We'll go now to Senator Griffin.
Thank you.
Sorry.
Thank you, Mr. Chairman. I actually want to thank Chair Wilson, who started right where I was starting in my notes with some of the data and just catching the difference between minority versus African American. And so I that question has been asked and addressed. I did have a question, and I'm not sure if this is in your toolkit. Maybe when I have an opportunity to do a deeper dive there, I'll find it. But I was curious, both as the populations targeted by DEI policies and the concrete goals that you defined or outlined in your presentation. I was curious to learn if the states who have implemented those policies were required to produce evidence to support their race-conscious remedies. Because often in the state, as we implement programs, we're told it has to be preceded by a disparity study to ensure that we are not violating some federal or state laws. So could you talk about that a little bit and tell me if those states...
Yes. We didn't look at the number of states that conducted kind of those type of studies, but there's the equal protection clause in the Constitution that is the driver for those studies looking at the impact. And that's, I think any state that has legalized any form of cannabis knows there's going to be litigation over the awarding of licenses. And, that type of study helps support the state's decisions. Ohio, I think, is a stark example of kind of trying to do a race-conscious licensing system, but not having the evidence they needed, and kind of ran into that equal protection clause issue where they created like a license quota that was challenged, and they didn't have a study. But the problem is, the court pointed this out, that in a brand new industry, which was their medical, it's hard to get that study. And kind of the constitutional requirements for addressing past discrimination in an industry, it has to be industry specific, it has to be jurisdiction specific, and you can't use general discrimination. So, Maryland's in a different position in that we have an existing medical system. And so we can reflect on the challenges that system has had as part of that study. But yeah, it's this constitutional issue that this case in Ohio really highlighted, that you need to have your ducks in a row. For the lawyers on here, the idea of even if you have a compelling government interest, it needs to be narrowly tailored. And so those type of studies help in the development of policies that are better prepared to withstand the legal challenges that come.
No, I appreciate that. I just know that in the information that you presented, I wasn't clear as to which of these recommendations, the variables, the policies, the populations had that sort of foundation, because some of them seem a little broader, as Delegate Wilson was communicating. Some of them could cast a very wide net and not have the kind of impact that we're looking to have here in Maryland. So I was just,
No, and I think that's a valid point. And some of them do, not could, but do cast a very wide net. And that's the issue that I brought up at the end, is like, what is the state's goal? What is the state's goal? And that goal needs to drive how you define things. And, having an if your goal is very specific and you have an expansive definition of who qualifies for these programs, you're undercutting your goal, which, I think you make an excellent point in highlighting that, there's that challenge there.
Yeah, and if there is any background, the questions that are asked in these studies and the way that they're asked sometimes contributes to what the output is or what the final report or recommendations, who opines what at the end of the report. So I would be interested in seeing some of what other states have done in that regard. Thank you, Mr. Chairman, and thank you for your presentation.
Thank you very much. I have a couple questions that, and I see Delegate Chi has raised her hand, but if I'll jump in here for a couple questions, then I'll go to Delegate Chi. One of the first slides talked about startup costs, and you, I think it was 310,000 and a half million for another. Were those on average? Did you look at
It was
numbers
from
across the country?
a study a couple years old that looked at average startup costs outside of kind of the application fees, licensing fees. And, I think that's probably, I can't say this decisively, but just looking at some of the stuff, I think that's probably low for some of those categories. In preparing to discuss the Florida licensing system, there are already, the controversy over Florida's approach, they were saying just the application process alone, not even like standing up the business, was costing applicants between $500,000 to $1 million just to throw their hat in the ring. They had a $146,000 application fee for that licensing system, which was controversial because it was more than twice what the application fee was for the non-Black farmer license. So yeah, those numbers I think are a starting point for the conversation and may actually be more challenging. And I think you have a great resource with Director Tilburg and the Cannabis Commission. They can probably provide better insight on that.
I might be chasing my tail a little bit with the next question, but one of the characteristics that you listed as being one that was targeted as in creating social equity licenses was people of lower income. Fundamentally, as you pointed out, the cost to set up one of these businesses is significant, and it seems to. I recognize that some of the states were only maybe picking from 2 or 3 different characteristics to determine whether or not they were a social equity applicant. However, I'm assuming that states, when they look to see if someone was of a lower income, was able to differentiate between their income and somehow their access to capital. And that to me, it sort of sets back on a feedback loop a little bit. We want to support people of a lower income, but it costs a lot of money in order to do this. So as we did in part with House Bill 837, we had set aside some money for technical assistance for people. And conceivably, you could see a system where there would be money to help communities be able to start up these businesses. But I guess take that into account a little bit.
Well, if you're going to, I think you bring up an important point that if in looking at the equity you're trying to create, if a state isn't providing some of that, the financial services in terms of access to low interest, no interest loans, to grants for startup costs and operational costs, you're not going to have successful, integration of lower income folks into this industry. And so, a term that you hear in regards to this is, are you creating equity just between the wealthy? Or if you invest in this type of financial supports, you can potentially create equity in a diversity of incomes as well. So, I think it's an excellent point. It's not a successful program if the state doesn't step in at this point and provide some of that financial support. And that all, the big part of that challenge is, as I highlighted, the federal law and how that limits access to capital. So yeah, it's a valid point, valid concern. You know, the partnering of some of these interventions, I think, are critical.
I think it's certainly something that's important. I'd like to see maybe get into the details again a little bit more. If you have further details, I won't dwell on it too much. But I do think that that's a kind of, it does act as a little bit of a feedback loop, is that we can set aside, or not even set aside, we can have these different characteristics, but if people can't afford to get in the front door, what's the point? And it doesn't mean we shouldn't do it. It just means it's an issue that we're going to have to address in some way, shape, or form. I want to go to another question, and then I really am going to stop because now Chair Wilson has raised his hand again, which means I probably did something wrong. Having said that, did you look at all? I mean, one of the questions that has floated around in our conversations about how we license is how many licenses, and whether licenses, in the midst
License caps, whether license
whether you have
caps.
license caps, whether to borrow from another part of the law, which the chair of judiciary gets to think a lot about, I think, in the next year, whether we are a may issue state or a shall issue state, whether we have a sort of cap on the number of licenses, which then increases those licenses value, which is kind of what we've done, well, more than kind of what we've done in our alcohol system. Or do you just say, if you meet these requirements, then we're going to give you a license? How does that interplay with sort of the social equity side of it?
That wasn't one of the variables that we assessed, but just kind of looking at it from a logical perspective, the argument is that by not having a cap system, there's greater opportunity. But the folks that enter this discussion, and this is something that I haven't really looked a lot into, is the success of the licensees once they receive the license. So, if you're releasing a large number of folks, how many of those folks are going to be successful in this less stringent caps, an uncapped system? Is one of the arguments. You look at some states where tons of licenses are issued, but not, how many of those actually get to, establishing the business. There's, kind of a fall off between that. And, I think there's issues that, it's an issue that I think is interesting that, I really haven't researched, but I know there's a lot of discussion around it.
All right, very briefly, the last issue, you raised both New York and Connecticut. Did any of those go to litigation, those systems that you laid out? And both of them, I think, have gone to litigation, correct?
I haven't been monitoring litigation in those two states, but I have a feeling anytime a license is awarded, there's a strong possibility that someone's going to have a problem with it, just from kind of the lay of the landscape.
Presume that is probably going to happen. All right, now we'll go to other questions. So we'll go to Delegate Chi, then we'll go back for a second bite to Chair Wilson. Delegate Chi.
Thank you, Chair Carpenter, and thank you for the presentation. I have a couple of questions. One is related to the state stepping in to act like as a landlord, if that's the way I interpret it. Was the purpose primarily to make sure they pass the zoning requirements of local counties, for example, or was it as a way to also mitigate the cost? Or maybe both?
Oh, sorry. I think primarily it was to remove that barrier of cost, but in addition, it's kind of helping with the challenging logistics of locating it. So it's an issue, I think, of cost and logistics. Just reading, the language and the laws, and on the agency website recently, I didn't see anything that said, this is primary, this is secondary in terms of our goals.
Is it working well for the states that stepped in? Is there any liability?
This is brand new. So they are right now, you know, they did a call for applications for those retail licenses. And I think the application window closed towards the end of September. And they've set up the structure for this fund. I know the state has put out a call, you know, for a manager of this fund. So this is in the very early stages. So they haven't, you know, been securing these properties yet, to my knowledge, because they're so early in the process. It's just, you know, I highlight it because it is a unique approach. You don't see any other jurisdiction kind of doing this.
Right, and I assume if they do that, conceivably there could be more than one tenant or player in one location, which is also an interesting dynamic, right?
Oh, I'm sorry. I don't think in terms of multiple tenants at one location.
Yeah, is that possible?
In terms of when you say location, like, are you talking like local jurisdiction or, you know,
A physical location, because if the state acquires a piece of property and then, you know,
so
works with businesses.
looking at this, the state, I think, is looking, you know, I think the goal of this is not to purchase the properties to then lease to them, but to locate properties that can be leased and then built out so that the licensee would be the sublease. But yeah, I don't know what restrictions they've placed in terms of proximity. I know some states have proximity restrictions in terms of how close retail locations can be to each other, but that's an interesting issue that I don't know the answer to.
Okay, could I ask another question about the conversion? It looks like it was extraordinary amount of money somebody had to pay, like $3 million. Whether it's upfront or over a time period, I wonder how many people actually take the bite. Like how many players, when the market opened from medical to adult use, actually voluntarily applied to convert? Do we have that data?
Well, in terms of, I don't have the data, but because the adult use market is a more profitable market, you have a bigger audience for your product. Medical dispensaries, you know, generally speaking, want to get that dual license. And I looked at a map of Illinois' retail locations today, you know, because that's what I do. You know, in my free time, I'm just looking at retail location maps. And on that map, the majority of the retail locations were that dual license. Very few, and I think that also goes to where they are in their licensing stage. Very few were kind of retail only, and I think even a smaller amount may have been just medical, because I think the financial gain in being able to access that adult use market is very attractive. But to the issue of how many of those folks who want that opportunity are just going to pay the fee versus, you know, participating in one of those programs, I don't know what the data is on that. And I don't know if Connecticut is far enough along to actually have that data on their program.
Thank you.
Chair Wilson.
Thank you, Mr. Chair. I wanted to get one last bite at the apple here. I guess there's a lot of people reaching out to me because, you know, everybody sees this as in the license is a winning lottery ticket. And my questions go along the line. One of the goals, as I see it, is to create, especially within the communities that were disproportionately impacted by the war on drugs, to create generational wealth. But as you know, businesses fail all the time, and these are businesses. And so when we talk about access to capital, and we talk about bad credit, we talk about inability to run a business, how do we do this in such a way, as far as our criterion for our licensing structure, that will bring the best in? Because we're going to have no end of applicants, especially if we make this a refundable low bar. We're going to have no end of applicants. But what's difficult is, again, sometimes you got to go for your A students, the people that have ran businesses, because otherwise my worry is in 10 years, and I saw your graph about how valuable this industry is going to be in 10 years, that in 10 years, we're going to have very few minority business owners participating if they were not the ones who know how to run a business. And as part of that, the set-asides that I've seen through the other states, my concern with those is, what's to stop old white dude from just coming out right afterwards and buying that license up? Because again, in 5 or 10 years, if we don't have 30% minority participation in the market of Maryland, then we have failed as a General Assembly. And part of that is making sure that it's consistent, making sure that these licenses stay within that minority communities. And I know that you gave a lot of great detail, but as far as how do we ensure that we don't, in 3 years, they're not all gone or bought up?
I think these are all valid issues and concerns. We didn't really look at the issue of restricting transferability. I know some states, you can only transfer your social equity license to another business that qualifies as a social equity license, or they may place a time period in which that license is not transferable. So I know that is an issue that is being debated out there because of this idea of, and I think it goes to goals. If you have an incredibly valuable license and you sell that license, there aren't any kind of transfer restrictions. You're making generational wealth for your family, depending on the license. And so you've helped one family, but it's the idea that, you want to keep that license within, the targeted community and grow kind of the business community rather than, an in and out economic opportunity. And that's a valid issue. And I think it's a challenge that states are struggling with. It's just not an issue we put in our study. So I couldn't tell you, what the breakdown is and kind of the various approaches to that.
And just for that, I think Delegate Chi asked about which medical marijuana businesses want to get into the recreation. All of them, every one of them. I've yet to meet somebody, especially because medical marijuana coincidentally drops precipitously once recreational marijuana becomes legal. So everyone's a taker.
Okay. Are there further questions from work group? Going once. All right, seeing none. It's about 8:15, so we've managed to stay on time. It's a miracle. And we want to thank Matthew Swinburne for joining us this evening and appreciate your time and the work that you've done gathering this information for us. If work group members have questions for Mr. Swinburne, or if you'd like a copy of the research that he's been putting together, you can contact my office at luke.clippinger@house.state.md.us and we'll connect you. Work group members will be back again in 2 weeks on November the 15th at 7 p.m. when we'll hear about tax structures in other states and how they've changed their strategies regarding the taxation of recreational cannabis to move people from engaging with the legacy market to the legal market. So continue to monitor your email accounts and watch the MGA's schedule for updates.
Mr. Chair, do we have to use the word legacy market?
No, I don't think so. I think that'll be probably the last time I do that, but okay.
Okay, it was funny though. Thank you.
Yeah, well, we aim to please here a little bit. All right. Now that we've, what can you do? Thank you all very much for being with us here this evening, and we will be back in 2 weeks. Thank you.